Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. So we are still on our motion for new trial, and I have covered every last page in that motion. The motion is actually 60 plus pages, but with the exhibits, it's 193 total pages. But I have combed through there, and there are things, and that's why you are seeing these videos in segments, but they're all in order. So if you have not caught up, definitely start with the reading of the motion for a new trial. I did the motion to recuse first, then I did the motion for a new trial, and then there are a series of videos in regards to that motion for a new trial. Well, I don't want to say hopefully, but as of right now, this is just part of the series. But one thing I did want to point out is the motion in limine, and I will explain what that is in just a second. If you pulled up the public court docket on the Collin County website and you search for a motion for limine, which is a pretrial document, you'll find nothing, zero. But guess what? One did exist the entire time. It just was never filed where anyone could see it, not even me being a paralegal. Today, I'm breaking down how that happened, why the defense says it happened, and why it's now doing double duty in the motion for a new trial. I'm Cassandra, your favorite paralegal, and this is Legal Doc Talk. So before I get to explaining what a motion in limine actually is, I want you to take a look on the screen, and this is the register of actions. This is the docket. So everything that gets filed is placed on the docket. The way that it works is so when I file things in any county in the state of Texas, we file what's called the Texas e-file system. That filing goes to the district or the county file clerks. They review to make sure that there's no administrative or clerical issues in that document. If everything is good, it will be accepted, and then they will go ahead and docket it on the docket, which is public for everybody to see. Going through this, you will see every single pleading, correspondence, you name it, on this docket. We get closer to the trial. Jury trial was scheduled for June 1st, 2026. You see absolutely nothing. Now, remember, I said a motion in limine is a pretrial document. So prior to June 1st, I should see something on this that is called a motion in limine, and it's not there. It's not there. It is not there. All right, so quick primer because this only lands if you know what we're talking about. Well, what I'm talking about. um, a motion in limine is a pretrial request asking the judge to keep certain evidence out before the trial even starts. Usually because it's prejudicial, it's irrelevant, or it could taint the jury if the other side just burst it out in front of them. These are normal. Almost every contested criminal trial has at least one, and they're normally public record, which is filed with the clerk, sitting on the docket for anyone to pull. So if I was to go up to Collin County right now and ask for the motion to limine, I would not be able to obtain it because it's not on the docket, meaning that it is not with the file clerk. That's what makes this case unusual. According to the motion for a new trial, this one was not handled that way at all. All right. So we're going to look at the timeline right quick. And this is really based off of Mike Howard's affidavit that he submitted. Because, mind you, there is no case file. The case file is sitting with Judge Roach in his chambers. So the trial attorneys or the appellate attorneys don't have much to work with other than what Mike Howard has presented in his affidavit, as well as the other individuals, what they presented in their affidavit. If you have watched the series, once again, you'll understand why those affidavits are very important. But let's go through the timeline. And if I'm pretty sure everybody has, looked up this affidavit and read it on themselves. But here's how all of this came together according to the filing. Okay. Starting in early May of 2026 of this year, the lead prosecutor proposed the parties try the clean case. And that prosecutor was Mr. Bill Worski himself, meaning based only on what happened under the tent that day, and neither side introducing character, reputation, or extraneous conduct evidence about either Carmelo Anthony or the Metcalf twins. That proposal got hashed out over a series of calls and meetings: May 5th, May 8th, May 11th. Then on May 21st, the parties brought the understanding to the judge himself in chambers. Off the record, no court reporter, no transcript. So, where's the actual motion memorializing all of this? According to the filing, it existed, but it was written in a deliberately generic language and hand delivered directly to the court on the very first day of trial. But it was never entered into the district clerk's public file. And I could go back to that and I could show y'all what it says on the first. And you guys can see that right here. The only thing that we see on the first is the general docket entry where the jury pool was seated and the jury chosen and jury trial. That's it. That's all. Why hide it? The motion for new trial says the goal was to keep the media from reporting on the specific bad act evidence both sides had agreed to exclude, meaning the prior conduct, character, and extraneous offense evidence tied to the defendant and the Metcalf twins. Now, sit with that for a second, though, because there's something almost circular about it. The reason given for keeping this filing off the public docket is the intense public interest in this case. But that same public interest is exactly what the Sixth Amendment public trial right exists to protect against being curtailed. You don't get to use the case being high profile as the reason to close off public access to how it's being litigated. Okay? This fact isn't just interesting trivia. The defense is using it in two completely separate arguments. And we pretty much covered it in the videos that I've done. First, it feeds the Sixth Amendment claim. Remember, the public trial argument isn't just about who could physically sit in the gallery. The motion argues that substantive pretrial litigation in this case, real fights over what evidence comes in, happened entirely out of public view. No pretrial hearing on the docket, no filed motion in limine. A member of the public checking the record beforehand would have found in the motion words nothing to read and no hearing to attend. That part of a broader pattern the defense says shows this trial was closed off well beyond just the courtroom setting. Second, it's the foundation of an entirely separate ground for a new trial. This is the piece that really escalates things. According to the motion, the defense built its entire trial strategy around this unwritten agreement. Its voir dire, its opening statement, its cross examination of the state witnesses, and critically, the decision about whether Carmelo Anthony himself would testify. And that's exactly what Mike stated in his affidavit. That's exactly what he stated in his affidavit. Then, mid trial, the state reportedly argued the defense had opened the door to exclude evidence through its opening statement, and that the original understanding had never contemplated Anthony actually taking a stand. The motion frames this using the Supreme Court's reasoning in Santabello versus New York, which the idea that one side induces detrimental reliance on a promise and then revenges on it once that reliance can't be done or can't be undone. I'm sorry. And that raises a serious fundamental fairness problem. The claim here is that the state got the benefit of the defense holding back on cross examination and opening statement strategy, and then changed the rules once the defense couldn't take any of that back. Ain't that wild? So Bill and the prosecution office got what they want. But as soon as the defense came, oh no. Mm-mm. We can't do that. That's messed up. A few important caveats here because I don't want to overstate this. Everything I've just walked through comes from the defense own motion. It's their characterization of events, and the state has not yet had the opportunity to respond, cross examine, or offer its own account of what they actually agreed to and why they agreed to it. The motion itself acknowledges the terms of this understanding are disputed. That's precisely why the defense is asking for an evidentiary hearing to actually develop the facts under oath rather than argue about them based on competing recollections. And I know people are like, wait, an evidentiary hearing? Yes. So that is why they want to have an evidentiary hearing. And I'm going to hold on, let me go to the last, and I don't think a lot of people got that part. So I'm going to read this. This is the prayer on the motion for a new trial. Wherefore, premises considered, the court restricted the general public to a 10-minute daily admission window and provided no contemporaneous alternative for those foreseeably turned away without the findings. Waller requires. The resulting closure is structural error that a new trial is required to cure. Defendant Carmelo Sincere Anthony therefore respectfully prays that the court set this motion for an evidentiary hearing at which the facts concerning the closure of the courtroom, the delegation of the courtroom access determination to a non-judicial officer, the parties' unrecorded agreement limiting character evidence, and its repudiation, and the preservation and harm facts concerning the unsupported provocation instruction may be developed. Grant the motion, set aside the judgment of conviction and sentence, order a new trial conducted in a courtroom open to the public, enter written findings of fact and conclusion of law in support of its ruling, grant the relief requested in the interest of justice, and grant such other and further relief to which the defendant may be justly titled. So they want an opportunity for the state. I mean, they can always respond to the motion. All they have to do is submit a reply to the motion for a new trial and rebuttal whatever it is that they want to. But regardless, this motion has to be set for a hearing. But here's the kicker that nobody's understanding. They don't want Judge Roach to hear this motion. So the motion the motion to recuse, that has to be taken care of first before they can set a evidentiary hearing, and they need to get that out the way before they can say, okay, let's get a hearing on this motion for a new trial. So I hope that makes sense to everybody. So motion to recuse, the evidentiary hearing, because they need answers. They can't just go off of what Mike said. They can't just go off of what the affidavits of the members of the public said. They need to get a response from the state, from Bill, Greg, and any prosecutor that was on this case. They need answers. Why was an agreement done off record? Where is the motion to limine? Why isn't it public record? What's going on with the case file? So this evidentiary hearing needs to happen before this motion for a new trial. So once again, we need to have another judge. So I pray and I hope that another judge says, okay, we're going to assign another judge to this case. When that happens, they can schedule a evidentiary hearing so they can get the answers that they need from the state, and then they can move with the motion for a new trial. Okay? So this is exactly the kind of detail that's easy to miss when we're scrolling through the 60+ page filing, but it ends up mattering for two totally separate legal arguments. Now, I'm going to keep tracking whether the court grants the evidentiary hearing. So make sure that you are following me. Set that notification on. Hey, you might have to unsubscribe, then subscribe again, but don't miss it. Now, also drop a comment if you want me to go deeper onto the Santabello reliance argument next, okay? All right. But I'm Cassandra, your favorite paralegal, and this is Legal Doc Talk. Don't forget to like, share, and subscribe this video to the masses. We are trying to spread a word. We are trying to ensure that everybody understands what this process is, what it entails, and why we need to be. Now, I don't want to say we need to be patient, but I want you to understand why we're not jumping ahead to this while we're doing this. So remember, motion to recuse, evidentiary hearing, motion for a new trial. That's the order. Oh, and let me give my disclaimer. This video summarizes allegations and arguments made in the defendant's motion for a new trial in the state versus Karmelo Sincere Anthony. These are the defense's characterization of events. The state has not yet responded to or been cross examined on these claims, and no court has ruled on their accuracy. This video is for legal education purposes only and does not constitute legal advice. All individuals are presumed innocent unless and until proven guilty. Once again, I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. Bye.